Nothing happens. Okay. I have a question about what you said about facultative mixity, or which is linked to what Fernando said about the link or the absence of link between shared competence and mixity. And I quite agree with the idea that this is not because the EU has a shared competence that it has to conclude the agreement with the member states. So, in my opinion, shared competence does not lead necessarily to mixity. And I wonder what role plays the principle of subsidiarity in this context. I mean, if we are in a shared competence, that means the general principle of EU law apply. And the general principle for the exercise of shared competence is principle of subsidiarity. And the condition of laid down in Article 5 of the EU. So I wonder which is the role of principle of subsidiarity, and if it's not could not be a kind of limit for the facultative mixity you mentioned, Mary. Thank you.
We collect all the questions. I think this is the shortest way to do. Other questions? Yes.
My question also relates mainly to the last presentation. Thank you very much. It has more to do with what the others said than what you said, because you mentioned that several general advocates refer to this idea of unity of external representation of the European Union. And Advocate General Kokot and also others try, as far as you said, to use that unity as a means of trying to get rid of, I say it in my words, to get rid of the member states. Yes, but if we really take that serious, actually, that contradicts to the practice which we find currently within mixed agreements, because when you have mixed agreements, Commission, Council on the one side and Member States on the other side, they try to find agreements or cooperation on how to define their external position and who speaks for the European Union or for the Member States. You know, these cooperation or interinstitutional agreements, and this clearly shows in my thinking that the unity of external representation does not require, at least when we look to the institutional practice, that the member states are out of they are driven out of the exercise of their competences. Actually, this institutional practice shows me that unity only is a requirement which places a burden on the member states and on the Commission to find a way of cooperating under the loyalty principle of Article 4.
Thank you. More questions? Yes.
I also have a comment regarding, or a question regarding mandatory mixity. When the court discusses the facultative character, or when the court discusses the necessity of mixity regarding investment protection, it simply notes that the European Union does not have exclusive competence in that respect, because the provisions of the treaties deprive the courts of the member states of a jurisdictional competence, which means that the agreement the competence must be shared. Shared in this case probably is not a very fortunate word because it's used out of context. It does not mean shared competence within the meaning of the TFEU. Probably it's shared meaning just non-exclusive. So in my understanding, that part of the judgment kind of works and does not imply that the court actually wanted to contradict the theory of facultative mixity. Will that make sense in your view?
Okay. I would have made the same question. The last one. Do we think that this is the final say of the court about mixity and exclusivity? Because I think that this is a very progressive development. And the idea is that if the court now tried to make this Singapore opinion as the standard. Probably in the future states will be more shy in demanding mixity. This is what do you think about that? Thanks.
Maybe a little bit covering, but briefly everything. Subsidiarity, does it play a role? No, but I will explain why. Subsidiarity normally means that you think at European level, you do at European level, you establish common rules whenever it's necessary, but basically there are things that you don't do at European level because it's not necessary, so you leave untouched the variety of legislation you may have in the different member states. Germany may have a choice, Portugal has a choice, Greece has a choice, fine. At the international treaties, it's a bit different, because if you say mixity happens in a situation where you have the Union, it covers certain parts, and the 28 member states claim to have retained competence for the other parts. But by concluding collectively these 28 member states, the treaty in question, they are not exercising their freedom of choice to have different legislation. They are agreeing to have a common legislation through a treaty. Normally you could say, well, let's do it through the Union. So that's why, as such, subsidiarity, insofar as it leaves member states the choice to have divergent laws, doesn't make a lot of sense. But we are talking about an international treaty, which precisely the whole purpose of it is to create common law. So therefore, somehow, this mixity, which implies that the 28 with the Union will collectively legislate and have common rules, to me, it should be done through the Union, because they have created the Union precisely to act alone, in principle. That's why I think subsidiarity, at the very least, is not a very good, a strong argument constitutionally. Unity representation may be a better one. I mean, it was mentioned sometimes member states do leave some representation to the Commission, but that's gone. That one there was more than 10 years ago when member states trusted the Commission. The member states do not trust the Commission anymore. Therefore, they don't give any role to the Commission anymore, and whenever it's possible, they will tell the Commission to shut up, or they will reaffirm their power of international representation, of being visible at the international stage for questions of prestige or political questions. So, yeah, I mean, in other areas that was possible, but it's not possible anymore. ISDS, how do we interpret? I don't know. And one possibility is to interpret that this was a national competence, not even a shared competence. It was a national competence to take away the powers of the judges. But if that is so, that means that the EU cannot, let's say, this is a competence which is not conferred to the Union. That means that the Union could not even adopt a regulation or a directive depriving national judges of their powers, which maybe it is so. But to me, the court may have been transforming an issue of substance. The court didn't like that the judges were deprived of competence into an issue of competence. And that, to me, is different. It's quite funny, because actually the court did the opposite as regards the issue that observes Advocate General Shapstone about termination of BITs, where there was this clause whereby the Union, this agreement would basically replace the old agreements between Member States and Singapore. And Advocate General Shapstone was more or less obsessed about this clause as going beyond the competence of the Union, even if it was trade policy. And the other court then did precisely what it did here. Is no. We are discussing competences here. In terms of competences, the Union has competence over a certain matter, and therefore can regulate how this treaty will eventually replace the other, or the relation between the different treaties. That's not an issue of competence. One may have thought eventually that the clause was, to me, the drafting of the clause was not particularly great. But that's a substantive issue, whether or not the clause was correct under international law. But here the court is examining compatibility with the treaties and issues of competence. The court didn't fall into that particular mistake. But here, maybe, I don't think it's a mistake, it's on purpose, actually, that it's a bit ambiguous, possibly leaving open the possibility later on to discuss about this issue. Is it the final word? Certainly not, because precisely, although this case exceptionally was discussed and deliberated by the plenaries of the 28 judges, precisely the appending case will have to help understand what shared competence is in the future, and I can imagine that eventually the very laconic reasoning of the court is actually on purpose, in order to give itself the possibility to refine things in the future.
Okay,
So
thank you
that
so
is my
much.
thought about the
Yeah,
treaty.
thank you.
Well, just a short one on the subsidiarity. Article 5.3 says, insofar as the proposed action cannot be sufficiently achieved by the member states. I'm just wondering, I hadn't really thought about it as much, but if you conclude an international agreement, isn't that a proof that the member states cannot alone achieve the objectives of proposed action? Well, that's just a question, but I haven't. And then, Wolfgang, your question, well, that's exactly why I asked the question myself. Isn't this just a practical argument? And in the court's jurisprudence, of course, the court itself says practical arguments. Whenever the Commission tried it a couple of times in the 1990s, having a mixed agreement would make things more complex. And the court said, well, this is a practical argument which cannot affect the fundamental question of competence. So, well, it's right, as you say, if it can be shown that there is unity, it becomes just a practical question. It would be easier, even easier. You wouldn't need interinstitutional agreements, but it couldn't be a real argument, as you say. And then, Mauro, your question. Yeah, I think it's also remarkable that the court, unlike the Advocate General, never identified an exclusive national competence.
Well, it couldn't.
Well, it didn't.
It could.
No.
Well, there was one.
All what is not attributed is by
termination of
definition.
bilateral treaty Sharpson said that exclusive national competence. Only the member states.
All what is not conferred upon the EU is by definition competence of the member states.
Yeah.
So,
Well,
the principle of confer.
yeah.
Yeah, but the Advocate General's opinion at the end recapitulates
The
and
treaty,
defines
the principle
three
of confer.
categories: exclusive, shared, and national. National, the only one is the right to terminate the treaties, the idea of the member states is for the member states themselves, never for the Union. That's what they
Well, this is the principle of confer. Christine?
Yes, it's just an observation on the unity of representation of the European Union. I think I share your point of view, Wolfgang, that it is really a rather practical argument. If you take the example of Opinion 194 and the participation of the communities at that time and the member states, it was concluded that it was shared, and in the same time the court was just insisting on this unity of representation. So we are in the same kind of situation where we would have a shared competence, but exercised or represented by the European Union. So I think I share the point of view which was expressed that it's not convincing argument than that in the way it was presented in these two approaches. Yeah.
Okay. One more question? Jan? Oh.
We're all afraid.
I have a very brief question on e-hearing.
There's a microphone up there, you want?
Yeah, you have your microphone.
Shall I
Yours
risk?
is working
Yes.
better than
Okay.
mine.
Well, it's not okay. Good. I have a brief question on this sustainable development point that Fernando also referred to, and the following. I mean, how far can we go in that? The court refers to sustainable development, the fact that CCP competences have to be exercised in light of the general objectives of the Union's external relations. In other words, all the objectives that are listed in Article 21 of the TEU. How far can we go with this? For instance, if the EU in a trade agreement inserts a human rights clause, as a so-called essential clause, saying that this is an essential part and therefore violations can lead to suspension and whatever. Can we just say that's all exclusive competence? Can we do the same when it is about other objectives in Article 21? How far can we go with that reasoning?
To me, the essential sort of human rights clause as such doesn't negate exclusivity. It's just somehow we share certain values. Eventually, you start breaching human rights, I will terminate the treaty. The court said in the 90s already. To me, I mean, the court has already said that this human rights clause doesn't render mixedness. But I agree. I mean, what is the limit? Here, the idea was that you were somehow regulating the conditions under which trade was going to develop. It's interesting, the Advocate General didn't follow the reasoning. The Advocate General agreed that whenever you are using typical instruments of trade for environmental matter, but typical instruments at the border and things like that, or there was a clear conditionality link between the social, environmental, and trade, that was common commercial policy, but didn't find any conditionality here. The court, it's true, sees with further, and even 161 said you can terminate. So this, at the end, obviously, that means that, yeah, you can terminate. You could argue that if you apply this too widely, you can, anything come in common commercial policy. You can just put anything in the treaty, and insofar as if you violate, I don't know, you can put a clause on transport. I mean, you could actually transform transport into a common commercial policy by saying, well, if there is a breach of the article on transport, I will suspend the trade provision. Remember, Daiichi, one of the arguments was countermeasures, which obviously, to be honest, is a bit counterintuitive, because the idea that something is common commercial policy just because you can trade measures, then anything can be. So again, what is the limit? I don't know. The court tries to define a limit in 164 and 165. The limit would be if you try to regulate the conditions under which trade is going to develop on equal footing. So basically, if you're not trying to influence your levels of social policy as such, but just ensuring some minimum rules, then it's fine. But again, what the limit is, we'll see. I mean, indeed, there could be treaties where this is more, possibly maybe not CETA, maybe not TTIP, maybe other treaties where the Union is going to have a more detailed regulation of this may become an issue. That's why I said at the beginning, what the Commission or the institutions are going to do in future agreement will depend on the content. If it's similar, the chapters on sustainable development are very similar to this one, no problem, the court has said it's exclusive. If they are more intrusive as to the laws and regulation, environmental and social regulation, which are included and have to be complied with, then, yeah, you may have a problem.
Yes,
we don't know.
I will say it is the center of gravity. It depends. The close center of gravity. It can be ancillary. It can be depends because you make an hypothesis.
Maybe, I don't know, one could look at these different on sustainable development and on human rights clause, I would say in a kind of gradation, because the human rights clause is a conditionality and it's an essential element, which is not, in my point of view, the clause about sustainable development. So because I would say that this is the difference. So if it is not an essential element, it could be part of common commercial policy, whereas it is an essential and completely independent clause, then the court look at it differently. This is the way I understand it, at least from the reading of the court. It's even if there is a possibility to terminate, but it's not the same. It's not the same force for the the requirement. I think it's a softer clause to be integrated in all these free trade agreements in order, instead of having nothing on sustainable development. Then you have the first level, which says you, contracting party, you have to comply with your international obligation. And this is the equal playing field for us to trade together. So this is, which is a different level, I would say. This is at least, maybe it may be evolve to something more essential in the future, but for the time being, I think it's still on this level. Thank you.
Okay, thank you to everybody. How much? 10 minutes of break. Thank you to everyone.